Theo Boshoff will just do a quick welcome, and then Gerard will give us a bit more background as to why this forum has been established and what we are trying to achieve through that, and what's going to happen today. So allow me to quickly just share the program again. It's a very, very simple program. There we go. We're going to have the opening welcome, some background briefly, and then Lucinda is going to get straight into the training. So Theo, I'm going to give over to you.
Thanks very much, Annelies. And good morning, everyone. Great to see so many people online. I think it shows the value of the initiative and the interest that there's been. So welcome everyone, and thanks again, Gerard and Annelies and everyone for setting this up. My name is Theo Boshoff, CEO of Agbiz. So I think I'm definitely not going to take 10 minutes. My job is very, very simple. It's simply to welcome you all today. I hope it's a productive session. I'm sure it will be. And thanks very much, Lucinda, as well, for making yourself available to share your knowledge with us. So I had a quick look, and I mean, just as a means of background, this is a new initiative for Agbiz and Agbiz members. Typically, what we focus on, or our broad vision, mission, purpose, etc., is everything to try and make the business environment easier for agribusinesses, which includes reducing the cost, reducing the red tape, etc. So we typically do that through our policy advocacy, where things such as occupational health and safety, of course, features quite strongly. This, I think, is a new type of venture where it also fits broadly into the spectrum, in the sense that it's also reducing the cost to do business by sharing. I think by sharing some of the resources, sharing some of the cost when it comes to sharing this knowledge between agribusinesses. So colleagues, thanks very much. I think that's probably it for the introduction. I don't think I need to say any more. I'll rather hand it over to the experts. So Gerard, thanks so much, and we'll give it over to you.
Thank you very much, Steve. I must say I'm quite excited to see how many people have joined and the excitement around this. So firstly, just I think a big thanks from my side to the Agbiz Grain team. I think without your guys' commitment and punctuality, this definitely wouldn't have gained such momentum in such a short space of time. So thank you very much from my side for that. Just to give a quick background, and then just a quick overview for what we are wanting to do in future. So first, I want to take everyone back about 3 years ago with the outbreak of COVID. I think it was a very intense time for the SHEQ practitioners. I think it was a very turbulent time. It was a very difficult time to navigate through uncharted waters, where there was a lot of new legislation that was promulgated and published in a very short space of time. And I think that there were many questions, a lot of uncertainty, and I think that was the assistance and the information that we received from the Agbiz team was of a lot of value, and I think that was the spark that started the initiative of this forum. I think just during that time, the interpretation of that legislation, things like the traveling permits for our industry, what are the do and do nots? I think that was very well communicated, and I think we all profited from that. And so a couple of months back, we got together and we said maybe we must elaborate on that and see what value we can provide to the agricultural industry as a whole from a SHEQ perspective, and that's how the SHEQ forum came about. So so that's just regarding the background. And I think looking forward, there are mainly two aspects that we want to focus on at this stage. And the first aspect is that I think there's a lot of legislation, there's a lot of information out there, and from this forum side, we can endeavor to process that and to assist the SHEQ practitioner in our industry to have from this forum to receive information that is constructive and that is that we can use to implement in our operations on a day-to-day basis. So starting off, we are looking at doing workshops once a quarter. So that would be more or less 4 workshops a year. And these workshops will then be hosted by subject matter experts that will then obviously engage with us regarding specific legislation and so on. So the invitation is out there. If you guys have any suggestions or questions or topics that you would like us to look at, then please send it through. We'll definitely have a look at it, and obviously we'd have to package it because we only have, or actually rank it because we only have the 4 opportunities in the year. I think in the near future, we're going to look at the electrical installation and the hazardous classification zoning. And this originated just from a government gazette that was published very recently, and the questions that related to that from the industry side. So we'll communicate that through to you in the foreseeable future. So from the forum side, I think the endeavor is to make that information available and to create an environment where we can learn from one another. And then also experts. The second endeavor is to look at creating industry benchmarks. And I think the starting point which we've decided on is to look at lost time injury frequency rates and total injury frequency rates. And I think because we're using Agbiz grain as the vehicle for this, it's a natural a neutral ground that we're using. So we will then communicate very soon. We will communicate the information regarding that, how to calculate it, what information we need. That will be given through to Agbiz grain, and they will then the forum will then analyze the data and then publish to everyone the industry standard. Because I think at this stage, if you go onto Google or any of those platforms and you Google industry benchmarks, you basically find manufacturing or other industries benchmarks. And although it's good, I think it will be great to have an industry standard for what we do. So that's a brief overview of what our vision is for the SHEQ forum, and obviously we also need to take an account as we go along. You know, we will elaborate and find new ventures, etc., which will introduce to the forum as well. So yeah, I hope that gives you a quick overview of the SHEQ forum. Without further ado, I'd like to introduce Lucinda. So Lucinda is the managing director from a company called Implex. Lucinda is most definitely a subject matter expert in terms of the legislation. She can elaborate on what her company does herself.
Gerard, you're on mute.
Gerard, you're muted.
sorry, I'm not sure what happened there. Thank you very much. So Lucinda is definitely a knowledgeable person, and she's made a lot of groundbreaking headway within the health and safety environments and so on. So Lucinda, thank you.
Gerard, you just muted again.
Sorry, I'm not sure why that happens, but anyway, so yeah, so Lucinda, thank you very much for the work that you've done, and yeah, for sharing your information with us. So over to you.
Thank you, Gerard. Can everyone hear me?
We can
hear you, Lucinda.
All right. I'm honored to be part of the team and to participate in today's session. Just by way of introduction, before so that you can see me, this is the face for the voice that you'll be listening to for the next few hours. I'm going to share my screen and turn off my camera, if you don't mind, after my introduction. As Gerard said, I'm the managing director of a company called Implex. What we do is we focus on legal compliance solutions. So in the safety, health, and environmental sphere, our business is to proactively assist employers in understanding the legislation, different laws on different levels, national, provincial, and local, and also to implement and comply with the legislation. To this end, what we do is we've developed software. We do legal compliance audits, we do consulting work and opinions, and most of all, we do training. And we try and do training in such a way that we demystify this legislation, because there's a lot of legislation and not everybody is on the same level of understanding when it comes to the legislation. So we've been doing this, and I have specifically been in this field in the Implex capacity for the past 17 years. And before that, I worked at an organization called the National Occupational Safety Association, where I was introduced firstly to systems, and that enabled me to combine legal knowledge with systems knowledge to come up with a way to proactively comply with the legislation. So I think we've put together a presentation for you. I'm going to share my screen with you now and then get right into the presentation. So let's get going. If you can just by way of a thumbs up indicate that you can see the slides show. Now I've locked myself out here. I can't see your thumbs ups.
Yes, we can see the screen.
You can. Sorry about that, guys. All right. Thank you for having me and for giving me the opportunity to share my thoughts on the matter with you. What we're going to be looking at today is we're going to look at two specific health and safety acts. On the one hand, there's the Compensation for Occupational Injuries and Diseases Act, which we refer to as the COID Act. And on the other hand, there's the Occupational Health and Safety Act, which we refer to the OSH Act or OSHA. So when we're looking at this legislation, both of these acts fall under the purview of the Department of Employment and Labour. The one under the Compensation Commissioner and the other under the Health and Safety Inspectorate. So when we're looking at the OSH Act, that's the one we'll look at first. I'm just going to create an understanding as to what the Act entails and then specific duties that of an employer. And then after that, we'll look at the COID Act, the role players, and understanding the requirements in terms of the COID Act. Now, whenever I do training on legislation or workshops on legislation, I try to always take one step back and start with interpretation of the law. We often find when we're doing audits that we look at procedures And we find that people interpret the legislation.
Lucinda, you muted?
This muting. Sorry, do you hear me?
We
Can you hear me
you
now?
yes.
I'm not sure why that happened. Right, where was I? We often find when we do compliance audits that employers interpret the legislation differently, which if you look at it, the law is based on a principle of self-regulation. So it gives you a basic requirement, and then it allows the employer to implement what the employer sees as reasonable steps. However, your starting point has to be aligned with the legal requirements. And to ensure that you do that, there's 3 basic rules of interpretation of the law that we like to look at. The first and most important rule of interpretation of the law is that you have to start with definitions. This is the most difficult thing to teach people, because when you're writing a procedure, say on the SHEQ Act, you've got to go, and as the employer, you have to go and look at the definition of who is the employer, right? And in the SHEQ Act, the definition of employer, for instance, excludes a labor broker. So that means that an employer is somebody who provides work but cannot be a labor broker. Now, the SHEQ Act deals with incidents. So an incident is an accident in the workplace where somebody gets injured, and then that has to be reported. So for the purposes of the Occupational Health and Safety Act, the employer excludes a labor broker. Now, for that same accident, the COID Act will also apply, which is another piece of legislation, as I've said. But in the COID Act, you also have to report to the Compensation Commissioner an accident. Now, if you look at the definition of employer in the COID Act, it includes a labor broker. So that means that when we're interpreting the law, we can't have a standard definition for who is the employer. We have to use the definition applicable to the law that we are working with at the time. So that's the first thing you need to look at when you look at interpretation of the law. You always start with definitions. So in the session today, if you see this symbol, and if it is in the top left-hand corner over there, that will indicate I'm giving you a definition. I'll, of course, also tell you that. So just remember that for afterwards, if you do get a copy of the presentation, this symbol in the top left-hand corner indicates to you this is a definition. So we start off with definitions. That's also applicable when we're writing a procedure. We need to make sure that for our procedure, our definitions in our procedure are aligned with the definitions in the legislation. The next thing we look at when we look at interpretation of the law is the question as to what happens if there's no definition. A good example, for instance, here would be Section 24 of the SHEQ Act. Section 24 of the SHEQ Act deals with incidents that must be reported to the inspectorate, the Department of Employment and Labour Inspectorate. And under Section 24, it says, each incident occurring at work and in connection with work, where a person dies, becomes unconscious, suffers the loss of a limb, or is otherwise injured, or becomes ill to such a degree that they're likely to die or suffer permanent physical defect, or if they're away from their normal work for 14 days or more, must be reported. Now, if we take those 14 days or more, what we would do if we're interpreting 14 days or more, we would say, right, is there a definition for days in the Act? And there is no definition. Now the question comes up, would this be 14 work days or 14 calendar days? Right? Now, if you look at that, does it really make a difference? Yes, it does. Because if you're looking at 14 work days and your work week is a 5-day week, that's close to 3 weeks. But if you're looking at 14 calendar days, then your work week is 2 consecutive, your work week is not considered. It's 2 consecutive weeks, irrespective of how many days a week you work. Now, most people go with their gut or their common sense and they say, right, it's a work-related injury, and therefore we look at work days and not calendar days. And that would then be incorrect, because when you're interpreting the law and there's no definition, the next step is to give an ordinary everyday word its ordinary everyday meaning or its dictionary meaning. And when you go to the dictionary meaning of day, that's one day following another. It's consecutive days. So that's 2 weeks flat, not just work days, 2 weeks, 14 consecutive days. All right, so that's the second rule of interpretation. When you're looking at the law, you start with definitions. If there's no definition, then you use a dictionary meaning. The third step in interpretation of the law is you don't interpret the law in isolation. So you'll see when I go through the SHEQ Act, I'm going to tell you about I'm going to tell you about the Act, the regulations, and the standards. So when you're complying with the law, when your responsibility is legal compliance, you don't just comply with one part of the law, you comply with the law in its entirety as it applies to you. So to comply with the law in its entirety, you need to understand the law in its entirety. So we don't look at the law in isolation, we look at the law in its entirety. Bottom line, when we're looking at this, is you have to understand that should something go wrong, you cannot come back and say, oh, I'm sorry, I did not know we had this law. Oh, I'm sorry, I didn't know the law required this. And for that, we've got a common law principle, and it always helps when we throw in the fact that it's a little bit of Latin. People seem to take it more seriously. Ignorantia juris non excusat. And this means that ignorance of the law will not be accepted as an excuse. So we can't say, I'm sorry, I didn't report this incident that happened in my workplace where an employee was seriously injured because I didn't know that this law applies. Right? That will not be an excuse. Right. So what am I saying? When we're interpreting the law, we have to look at the law in its entirety. So to simplify the law for myself, what I've done is I've said, right, I think of the law as the body of law. And when you're looking at a body, the core of your body, the part that you cannot go without, that's going to be your brain and your heart. So that's the part of the law that we cannot go without. So for our purposes, when we're looking at this law, that's our body. You'll excuse me, I'm not an artist, so my artistic skills are a bit limited, but you can see that's my body, right? So that's the core of my body. It's my brain and my heart. Now that we call the principal legislation. In the case of the SHEQ Act, that would be the SHEQ Act or the COED Act. That's the principal legislation. Now our body has arms and legs. Now, just for the record, our body can work without arms and legs, right? But an arm or a leg cannot work if it's not attached to our body. So for our purposes, the arms and the legs are going to represent regulations. So our act might have regulations, right? So if you have regulations, your regulations are called subordinate law. They are subject to the act. So you're never going to have a standalone regulation. Your regulation is always going to form a part of the act. So that's going to be our subordinate law. And then the last thing, especially in this legislation that we're looking at, is the hands and the feet of our body. That's going to be your standards, your SABS codes. You'll see in terms of section 44 of the act, the minister can incorporate SANS codes. And once the minister has incorporated a SANS code in the act, it will be deemed to be on the same level as the regulation. So in other words, when we're saying we need to be legally compliant, if a SANS code has been incorporated and it applies to what we're doing, we will also be required to comply with that SANS code. That makes it tricky because unlike the regulations the SANS codes are not published in the government gazettes. So that would mean that we would have to go and obtain a copy of the particular SANS code to make sure that we comply with it, only if it applies to our operations. The next component of hands and feet, you'll see Section 40 of the SHEQ Act says, if you cannot reasonably comply with a provision in the Act, then you have to apply to be exempted. Excuse me. If you're this exemption application is a formal process with prescribed steps that you need to take. At the end of the day, if you do get an exemption, that exemption will have conditions. So those conditions then become like an extension of the law, which means that you will have to comply with those conditions. So in addition to complying with the Act, the regulations, the applicable SANS codes, you'll also have to look at whether or not you have any exemptions and then what the conditions of those exemptions are. So when we're talking about your legal compliance or your compliance with the law, we're talking about compliance with the whole body, not just selected bits and pieces as it suits you. If it applies, you must comply. Now you'll see when we look at the SHEQ Act and when we look at the COID Act, the Act tells us what to do, but it does not necessarily tell us how to do it. So this then becomes quite difficult in our workplaces, because how are we going to make sure that our employees understand what we're supposed to do to ensure compliance with the Act? So what we then do is we take the legal requirements and we draw up our own procedures. So we're going to talk about Section 8(2)(e) that says you have to do a risk assessment, but it doesn't tell you what a risk assessment looks like. It doesn't tell you how frequently you need to do a risk assessment. None of that is stipulated in the law. The Act just says identify the hazards, assess the risks, and put in place controls to mitigate and eliminate those risks. So to enable us to do that, we are then going to write a procedure, and that's what tells us how to do it. So for most of us, when we're looking at this compliance that we have to take responsibility for in terms of the law, you're probably going to find, if you've done the procedures, of course, that you're going to find your steps in your procedures. And we've got different forms of procedures. You can have standard operating procedures, which would be your broader requirements. You can have your standard operating procedure being broken up into safe work procedures or written safe work procedures specific to a task that is being performed. And that can be broken up into further into work instructions. You can have of course, just have a procedure. You don't have to have all the intricacies. It can, the key thing to understand here is that the basis of the procedure is going to be your legal requirements. So if we look at the COID Act, reporting of our incidents. So we will have an incident reporting procedure or an incident claims procedure, or it can be an incident management procedure that incorporates all the requirements. But on a day-to-day basis, we're not necessarily going to be walking around with the Act under our arm so that we can ensure compliance. We need to make sure that we understand the procedures, because the procedures tell us how to do what the Act requires from us. So as we're going through this, I'll give you references to a few procedures that might apply to what we're doing in our discussion, what we're discussing today. Overall, what would typically happen is you would then take all of these procedures and put them together, and that would then constitute your health and safety management system. The health and safety management system would consist of all of these different procedures, and the procedures would be based on the legal requirements that we find in the different acts that apply to our operations. All right, that's just by way of introduction to the law interpretation and then the health and safety management system. If you've got specific questions as I'm going along, what you could do, if you don't mind, is you could type them for me in the comments section. And then when at the end of each section, I can look at the questions and I can see if we can answer them. And then we can also afterwards, I can summarize your questions with responses and send it to the team so that they can distribute a more formal response to specific questions from my side. I think we'll also have a question and answer session at the end. But if there is a specific thing that you think I didn't explain to your understanding or you need more info on, drop it in the comments, and that way we can track where I need to give a little bit more information. Okay, so next up, what I'm going to do is I'm going to look at these two acts. So on the one hand, we have the Compensation for Occupational Injuries and Diseases Act, the COID Act, and on the other hand, we have the Occupational Health and Safety Act, the OSH Act. Now, the COID Act it's not new legislation. For those of you who have been in business since before 1993, before we had the COID Act, we had the old Workmen's Compensation Act. So this is the legislation where if you get hurt at work, then you can claim compensation from the Workmen's Compensation, or these days we call it the Compensation Commissioner. So when we're looking at that part of the law, that's the COID Act. The OSH Act, also we got the OSH Act in 1993. And if you're looking at the OSH Act, that's also not new legislation, because before we had the OSH Act in 93, we had the Machinery and Occupational Safety Act. The big difference between the two was, of course, the fact that the old MOS Act, Machinery and Occupational Safety, focused just on the safety component. It didn't really incorporate health. And then from 93, they went and they said, right, let's not just look at safety, let's also look at health. So when we're looking at these two acts, as I said earlier, if you have an incident in the workplace, so somebody gets hurt in your workplace, then both of these acts are going to apply. But you're going to have to do different things in terms of each of these acts. So typically what would happen in your workplaces is your safety department. If you have a safety department or a safety person or a safety officer or somebody along the lines of that designation, your safety is going to manage the OSH Act requirements. And because your COID Act involves medical records and there's a confidentiality around those records, that would typically be done by human resources or an HR type department. But of course, it's not the act that says this is how it happens. That's just typically how we see this happen. If I've got a small operation and I do both, there's nothing wrong with that. It's just taking note of the fact that if you're going to go look for where these responsibilities lie in your operation, that's typically where we see it. Right, so let's start with the COID Act. What is the aims and objectives of the COID Act? What do we use the COID Act for? So the COID Act is used to provide for compensation for disablement. Now, disablement, I'll give you a definition of disablement. It doesn't just mean that you've lost a limb. You know, you've lost your legs or you're now disabled. Disablement also means inability to perform work. So don't use your meaning for disablement. Remember what I said? We're going to use the definition in the law. So it's to provide for compensation for disablement that is caused by occupational injuries. So workplace injuries or diseases. So an injury or a disease that I suffer because of exposures in my workplace. So it provides compensation for disablement caused by occupational injuries or diseases sustained or contracted by employees in the course of their employment, or also for a death resulting from such injuries or diseases. Now, let's get this straight. COID claim has never made anyone rich. The aim of the COID claim is just to compensate persons who have suffered because of work-related injuries and diseases. So this can, you'll see we're going to talk about the types of disablement and how it works, right? On the other hand, we have the OSH Act. Now, when we look at the OSH Act aims to provide for the health and safety of persons at work and for the health and safety of persons in connection with the use of any plant or machinery. So those persons, those are going to be the employees. It could also be contractors. We'll talk about the different role players. But the OSH Act also puts a responsibility on employers to protect persons other than those working for them against hazards to their health and safety as a result of what that particular employer is doing. So that's the difference. The one aims to compensate and the other one aims to put rules in place to ensure a workplace that is safe and without risk to the health and well-being of employees and others who may be affected by our activities. So technically, if we take our steps in terms of the OSH Act properly, then we wouldn't need to use the COID Act because nobody would have to be compensated because they wouldn't suffer an injury or an illness or die as a result of their workplace. That's technically if you look at it. Right, so let's compare. Under the OSH Act has punitive measures. So these are penalties. The OSH Act has penalties that says if you did not take these reasonable steps, then you will be guilty of an offense. And if they can find negligence, they can recommend a prosecution. This is a criminal prosecution in the magistrate's court. And if the person, and this person can be the employer or an employee, is found guilty of an offense in terms of this OSH Act, they will be liable to a fine or imprisonment in terms of the Act. So the Act determines what the fine or imprisonment is. So in other words, if the non-compliance is as a result of negligence in the workplace, and this leads to serious injury, illness, or the death of an employee, then there can be a criminal prosecution. So that's under the OSH Act. So for us, this is your criminal liability. Now, if you go look at the COID Act, the aim of the COID Act is not to punish us for not complying. The only penalties in terms of the COID Act would be if you do not register as an employer or if you do not report an incident, right? If there's negligence that leads to the injury in the workplace, they will consider it in calculating the compensation. But the main aim of the COID Act is to make sure that if an employee suffers an occupational injury or a disease or even dies, that employee or that employee's dependents are able to claim for compensation from the Compensation Commissioner. Because at the end of the day, the money that the Compensation Commissioner uses to pay the employees or their dependents actually comes from the employers. The employers are registered with the Compensation Commissioner, and the employers pay annual levies to the Compensation Commissioner. So that's what we do. We pay this to the Compensation Commissioner so that if our employees should get hurt in the workplace, they will have recourse. They can go and claim from the Compensation Commissioner. Well, they're not going to do this themselves. We're going to submit the claim for them in terms of the Act. Right? So that's the main differences between the Occupational Health and Safety Act and the COID Act. Now, I think the one thing we need to say before we look at the OSH Act itself is that compliance with these two acts, it's not a nice to have. It's not elective, right? We've got some time now. We can start looking at compliance with the OSH Act and the COID Act. Compliance with both of these acts is compulsory. And it doesn't just apply to employers with 50 or more employees or employers in a manufacturing environment. This legislation applies to all employers. You'll see the COID Act has a few exclusions, right? But overall, this legislation applies to all employers in all industries except for mining. The COID Act applies to mining, but the OSH Act does not apply to mining. In mining, the OSH Act has an equivalent called the Mine Health and Safety Act. So when I'm on a mining works or mining area, then we don't use the OSH Act, we use the Mine Health and Safety Act. But other than this, these two acts apply to all workplaces, big and small, across industries. Right, so this is the Occupational Health and Safety Act, OHSA. That's where we get it from, Occupational Health and Safety Act. You can see that this is not new legislation. This is a 1993 act and it became effective in 1994. So if you're looking at it, for almost 28 years, we have been complying with this legislation, right? For almost 28 years, we've been complying with this legislation, right? So if we're not complying with this legislation currently, that needs to tell us that, or it needs to be, I suppose, a wake-up call, I think, to say that depending how long we've been in business, if we can't say that we're complying with this legislation, we're actually at risk of non-compliance. Right. Do I think somebody is going to go to jail for not complying with the act? No, I don't think so. But do I think that if something goes wrong in our workplaces and we have not taken reasonable steps to comply with the legislation, and there's an investigation by the Department of Employment and Labor, our non-compliance will be seen as negligence? Then my answer is yes. So the time is now to make sure that we're complying with this legislation. Right, the OSH Act. Now, if you go look at the definition of this act, it confirms what I told you about the body. When we say compliance with this act, it would include not just the act, but in terms of the definition, also any regulation under this act. So that regulation, that's going to be the arms that I was talking about earlier on, right? So we start with this act. It includes the regulations, right? What are these regulations? I keep talking about the regulations. How would you know which regulations apply? So let's have a look. Under section, the S here stands for section. So this is section 43. Under section 43 of the OSH Act, the minister is authorized to make regulations dealing with any matter relating on health and safety. So basically, the minister can bring out regulations under the Act. So although the OSH Act itself hasn't been updated since 1993, what we have seen is a multitude of regulations coming out in terms of the OSH Act. So we've got different types of regulations. We've got general regulations, which I'll explain to you. We have got health regulations. We have got mechanical regulations, and we've got electrical regulations. Those are the 4 types of regulations that we have. So we only have to comply with the regulations if they apply to what we do. Now, the thing is, we need to look at what each regulation is and what it deals with to be able to identify, do we have to comply or don't we comply, right? Which I'll explain to you. Something that you can pick up in the regulations is that there are older regulations. There are regulations that actually predates the OSH Act. So if you look at those regulations, those were the ones that were published under the previous MOS Act, the Machinery and Occupational Safety Act. And you'll see in section 43, the Act says to us, a regulation made under the previous Act will be deemed to be a regulation in terms of this SHEQ. That's why we have the older ones. So let's have a look. Let's start off with the general regulations. Now, these are typically administrative regulations. So we start with general admin regulations that they've got administrative issues in, but they will apply to all workplaces because in the general admin regulations, you find the requirements for incident investigation and reporting. So those regulations will definitely apply. Then if we look at the general safety regulations, this is one of the older ones. The general safety regulations has specific safety requirements. So if you're looking for requirements around first aid boxes and the appointment of a first aider, right, you're going to find it in the general safety regulations. If you've got any confined spaces, if you're doing any stacking, if you've got any welding, soldering, flame cutting, anything like that, all up working with ladders, if you're making use of any ladders, all the rules around that, specific requirements, comes from the general safety regulation. So that one would generally be applicable. Explosives regulations wouldn't be applicable unless you're making use of explosives. If I'm looking at your operations, that's not going to be it. So we wouldn't have to comply with the explosive regulations. The construction regulations mainly applies to construction work. However, we can use guidance from the construction regulations if we're doing any working at heights. There's requirements in the construction regulations that would deal with working at heights. But overall, I don't think on a day-to-day basis that would typically be applicable. Now, if in your industry, you appoint people older than 16 but younger than 18, right? Then the health and safety of children at work regulations are going to apply, which if you look at those regulations, they put stricter controls in place for workers between the ages of 16 and 18. Major hazard installation regulations, if you have a bulk installation where that proves to be a high risk of explosion, for instance, or it's maybe bulk diesel, an installation like that, they've got quantities listed. If you store more than those quantities, then you will be considered to be a major hazard installation, and then you'll have to register. I think in general, you'd have to go and specifically look at what you're storing in bulk and if there's a risk associated with that, and then the quantities you find in the general safety regulations telling you how much of which quantity of which substance would constitute a major hazard installation. Something that's worth noting if the MHI regulations apply is that they published a draft with changes to these regulations. So within the foreseeable future, these regulations are going to change. It's still just in draft, so not yet implemented, but due to change within the foreseeable future. Right, so that's going to be our general regulations under the SHEQ. Our health regulations, now just quickly, how the health regulations works is that if you've got exposure to noise or dust, for instance, which you would have, exposure to noise or dust or chemicals, what's going to happen is you're going to have to appoint an approved inspection authority. That's an AIA. And the approved inspection authority is going to come and monitor your exposures. And now in the Act, we find something called occupational exposure limits. So it'll tell us what the noise is allowed to be over a specific period. Now, they are going to come and measure that noise in your operation. If it is under the occupational exposure limit, everything's good. If it's over the exposure limit, they're then going to tell you, right, you have to implement controls like personal protective equipment, PPE, personal protective equipment. And then the moment that you're over the occupational exposure limit, it means your employees are exposed to the noise, for instance. Then you have to do medical surveillance, right? You have to do medical surveillance, specifically audiograms, to see whether or not the PPE the hearing protection that you've given your employees, is it working? Now, the requirements for that, this basic process that I've just explained to you, this actually comes from all of these health regulations. So all the requirements are in there. Okay, that's when we're looking at the health regulations. Now, the first one is the regulations for hazardous chemical agents. This one was updated last year. If you have any chemicals, and you've heard about something called an MSDS. Now, an MSDS is a material safety data sheet, a material safety data sheet, right? The manufacturer has to provide you with a material safety data sheet for all of your chemicals, right? Yeah, sorry, I see a question. Who will be a typical AIA for occupational exposures? This is going to be an occupational hygienist. So what happens with AIA, Gerard, an approved inspection authority means that they are approved by the Department of Labor, Employment and Labor. They will be accredited by SANAS, the South African National Accreditation System, and then they will be approved by the Department of Labor for the specific exposures that they are focusing on. But it's typically going to be an occupational hygienist. It's not somebody that's typically appointed in-house. What happens here, it would be an external contractor that is brought in to come and do these measurements. So a good way to check is depending on what you're measuring: noise, dust, chemicals, biological agents, ventilation, illumination. All those are ergonomics. Those are typically the things that they measure. Is that you ask them for their certificate of approval, and their certificate of approval will then tell you what they have been authorized for. But yes, it's an occupational hygienist. Right. So you've got hazardous chemical agents. Just note that a manufacturer has to, or supplier of any chemical, has to give you a material safety data sheet free of charge with every chemical that they provide you with. The requirements for material safety data sheets is they have to be in a 16-point format. It's an international standard, right? So that 16-point format, if your supplier is not giving you a material safety data sheet in a 16-point format, then what you need to do is you need to go back to them and ask for it in the 16-point format. And if it's not in the 16-point format, and they say they can't give it to you in that format, then you need to change your supplier, because it is a legal requirement that it must be in that format. Because some of the information that you find on this, some of the information is what to do in case of an emergency. So there's fire requirements, what to do with fire, how to store the chemical, what not to store the chemical with, because there's potential for reactivity, and then also what to do in case of an emergency, your first aid requirements. So those are, and how to dispose of the waste once you've used the chemical. This is very important information that you need to take note of when you're working. Also, what the correct personal protective equipment is for that specific chemical. So very important, all the chemicals that you have, you need to make sure that you get this information. Material safety data sheet in a 16-point format. The lead regulations will have limited applicability. It's only if you have lead in your processes. I'm thinking very limited, wouldn't really apply to your operations. Noise-induced hearing loss, yes. Noise-induced hearing loss, this is going to be when you have noise and you wear hearing protection. That's most probably going to be applicable. Hazardous biological agents. Now, these regulations were updated in March of this year. The reason for it is, Gerard mentioned earlier on that there was a big wake-up call with COVID, right? And we had all of these rules for COVID. But we used to find the rules for COVID not under the OSH Act. Because COVID was a disaster, a national disaster, all the rules for COVID came through under the Disaster Management Act. Now, earlier this year, when the state of disaster was uplifted, then these regulations, where did all these rules go now? They're not under the Disaster Management Act anymore, and that's when they brought them in under the OSH Act, specifically under the regulations for hazardous biological agents. So with the upliftment of the state of disaster, the hazardous biological agents regulations were updated, and under there we've got a code of practice on managing COVID, because COVID's not gone, it's still there, right? And we still need to, based on the risk in our workplace, manage the COVID. So basically what these regulations tell us is we need to do a risk assessment, identify what the COVID risk is in our workplace, and what do we need to do to manage that risk continuously, even though it's no longer a state of disaster, right? Asbestos, from 2008 in South Africa, we don't have any asbestos production, any use of asbestos. So the asbestos abatement regulations would only apply if your operations commenced before 2008, and maybe still in the structures of your older buildings, there might be some asbestos containing materials in your roofing or in your gutters. And if you do have that, then you're going to require compliance with the asbestos abatement regulations. They brought out ergonomics regulations in 2019. This is definitely going to be applicable, because what you need to look at under ergonomics, and you can do your own risk assessment, you don't have to bring out in and outside person, but ergonomics is the impact that the workplace has on the body, right? So in other words, if I'm standing for long periods of time, if I'm bending, twisting, awkward positions, sitting for long periods of time, all of those things has an impact on the human body, which means it's ergonomics. So you are going to have to do an ergonomics survey or an ergonomics risk assessment in your workplace to identify what your ergonomic risks are. The next one is your environmental regulations for your workplaces. With environmental regulations for workplaces, we're looking at ventilation and illumination, right? And also, you know, when we're always talking about housekeeping, keeping the areas neat, putting your tools away when you're finished using them. All of those rules for housekeeping, we find it in the environmental regulations for workplaces. Facilities is basically our facilities. If you want to know, do I need to have toilets for my workers? That's where we're going to find it. What are the requirements? 1 toilet per 30 employees. That's going to be where we find those requirements. And then lastly, commercial diving, but that's not going to be applicable to our operations, so we won't have to comply with it. Then we've got the mechanical regulations. So when we're looking at mechanical, any driven machinery, so any driven machinery, that can be lifting equipment and lifting tackle if we have rotating machineries, saws, grinders, any driven machinery has to comply with the driven machinery regulations. Then we've got general machinery regulations, which, as you can imagine, would apply to your operations. Unless you have a lift or an escalator or a passenger conveyor, I'm thinking lift, escalator, and passenger conveyors are not going to be applicable to you. If you have a goods hoist, it might be, because goods hoists are under this regulation as well. Then we've got pressure equipment regulations. That's going to be for any pressure equipment, steam generators, vessels under pressure, even your handheld fire extinguishers fall under the pressure equipment regulations. Right, and as you can see there, there's another draft proposed changes to these regulations, so they are due to change within the foreseeable future. Once they've changed, we need to start complying with the changed legislation. Remember, you only need to comply. Okay, well, see, there Gerard is saying we've got lifts at the silos and material hoist. So that means lift, escalator, and passenger conveyor regulations are going to be applicable to those. Right. You only need to start complying with your draft legislation once it has been enacted. So they will publish in the Government Gazette a notice saying this law is now changed, and it's only from that point that we need to start complying with these drafts. And then the last two regulations is your electrical installation regulations. For all of your electrical installations, you need a certificate of compliance, and then your electrical machinery regulations. So that's specific requirements for electrical machineries. And if you happen to have electric fences, then you're going to have to, in terms of the electrical machinery regulations, depending on when your electric fence was erected, you're going to need to have a certificate of compliance for your electric fence energizer and your electric fence. So for the entire electric fence system. And that's going to be in terms of the electrical machinery regulations. Right. It's a mouthful, I know. But when we talk about the OSH Act, this is what we talk about. Not just the Act, but the Act and the regulations. Key thing is, you would have heard me say this, you look at the regulations, you look at what it deals with, and you identify, does it apply, does it not apply? If it does not apply, then I do not need to comply. But if it applies, then I will have to comply with the legislation. And then lastly, when we're looking at the OSH Act, something that makes compliance with the OSH Act tricky as well is the SANS codes. So what happens is, after each regulation, the minister then goes and publishes a list of standards, South African Bureau of Standards that are incorporated under that particular regulation. If the standard applies, like when we're looking at your handheld fire extinguishers, under the pressure equipment regulations, there's a specific SANS code that deals with the refilling and the inspection and testing of your handheld fire extinguishers. That means we then have to comply with that particular SANS code. All right, so understand, compliance with the SANS code is not compulsory unless the SANS code has been incorporated. If it's been incorporated, then and it applies, then we must comply with that particular SANS code. So that makes it quite tricky, right? You'll have to go and look in each of the regulations which SANS codes have been incorporated. What we could do, I've got a list of the different SANS codes that have been incorporated under each of the regulations. So I could make that available to the team, and then you could use that and send along to the attendees. We can also, I see there was a question on the training material. I can create a PDF of the training material, which we can also send to the attendees. You can then distribute that amongst the attendees. And then the same with the copy of the OSH Act, because it doesn't help that I tell you you have to comply with it and then you don't have a copy of it. So we could do that as well, Gerard. We could, if it's not already in the library, we could supply a copy of the OSH Act that can be put in a central library to be used if needs be. Right. So that's our copy. Oh, not copy now, I'm saying copy. Sorry about that. That's our OSH Act. So that's the setup of the OSH Act. Now, who are the role players in terms of the OSH Act? Now, when we're looking at the role players, your key role player is the employer. All the duties in the OSH Act are on the employer, except for section 14 and 15, which are the duties on the employee, right? So the employer must do this, the employer must do that. So who is the employer? Of course, if we follow our own guidelines for interpretation, we start with the definition of employer. So the definition of employer says it's any person who employs or provides work for any person and remunerates that person, or expressly or tacitly undertakes to remunerate that person. But, and this is the important part, it excludes a labor broker as defined in the Labor Relations Act of 1956. It's an outdated reference there. So don't go on the outdated reference. You're going to look at the latest Labor Relations Act, but where they now call them temporary employment services. But if you're making use of temporary employment services, the consequence of this definition is that when you make use of labor broker staff for the purposes of the Occupational Health and Safety Act, the staff provided to you by the labor broker will be deemed to be your employees. Because the requirement is not that you have to remunerate them only, but the requirement says a labor broker is not an employer for the purposes of the SHEQ Act. Right, so everything you do for your own employees in terms of the SHEQ Act, you will have to do for labor broker staff that you make use of. So what's the difference then between a labor broker and a contractor? The key thing to understand about the labor broker is the nature of the service that they provide you, right? The labor broker doesn't provide you, doesn't do something for you. They provide you with an employee or a person or a worker, right? So they provide you with the person that's going to do the work that you need to be done. So let's take a wall. I want to build a wall. I call the contractor quotes me and comes and builds the wall for me. But if I call the labor broker brings me a builder. I give the builder the necessary tools and equipment and I supervise them. They do the work for me. That's labor broker staff. What we need to understand importantly from this, and you're only going to find it in the definition. You're not going to find it anywhere else in the SHEQ Act. It's only in the definition of employer that you're going to find this. Insofar as it relates to labor broker staff, all the requirements that we have with regard to our own employees will apply to labor broker staff as if they are our employees. All right. So what are these duties that the employer has? Section 8 of the Act is the employer's duty. So if we're looking at section 8.1, that's the broad duty of care. Now this is the one that says as far as is reasonably practicable. Those are very important words. I'm going to give you the definition for that now and explain them to you. But you'll see that throughout the Act, everything says as far as is reasonably practicable, right? So this is a key part of the legislation. As far as is reasonably practicable, the employer, remember who's the employer, must provide and maintain a workplace that is safe and without risk to the health of employees. That's what the employer must do. As far as is reasonably practicable, the employer must provide and maintain a workplace that is safe without risk to the health of employees. That includes everything and anything. That's how wide this duty of care is. So that's exactly what it is. It's our duty of care to ensure as an employer a workplace that is safe and without risk to the health. That's why we look at safety risks as well as health risks. Not just safety, also health risks. Now, 8.2 then says, without derogating, which basically just means without taking away, without derogating from the generality of an employer's duty. What does that mean? It means without taking away from this general duty to ensure a workplace that is safe. The matters that we need to in particular address is the following, and that's A to J. So first and foremost, we need to implement safe systems of plant, machinery, and work. So that's the starting point of all of your health and safety management systems. If you have a maintenance system where you maintain your equipment, it's because of 8.2a and compliance with that, right? Safe systems of plant, machinery, and work that we have to have. What else do we need to do? 8.2b says we need to provide personal protective equipment. Now, PPE, personal protective equipment, that can be anything from a hard hat, safety shoes, overalls, hearing protection, masks, sanitizer, anything, machine guarding, anything that we give our employees in the interest of health and safety. But here's the twist. Before we give them the PPE, we need to first see if we can't get rid of the risk that requires the PPE. So if it's only as a last resort that we give them the PPE, otherwise we must try and get rid of the risk. C says to us, you have to stop any employee from doing anything unsafe or possibly hazardous. Now, D, this is the one that requires a risk assessment. What this means is that every employer needs to do a health and safety risk assessment. So now you need to ask yourselves, have we done a health and safety risk assessment? Or have I seen our health and safety risk assessment? Right? So we need to do hazard identification, risk assessment, identify the hazards, assess the risks associated with those hazards, identify what we're going to do to control and eliminate those risks, and then provide those measures to our employees, implement those measures. It's not good enough just to put it on paper. You need to actually follow through on it. Then, if you look at E, it's a very strange word that you see there, TC, T-I-S-I. That's just an acronym that we use. You need to provide your employees with the necessary training, instruction, supervision, and information so that they can do their work safely and without risk. Training, so we actually have to train them on the risks. We need to give them instructions on the risks. This could be a work instruction or a procedure, for a safe work procedure, for instance. Supervision, you'll see 8.2i also says we have to do the work under the general supervision of a person who is authorized to enforce the employer's health and safety measures. So that's where our supervisors come in, right? But our supervisors have to also then look at health and safety risks for them to qualify under 8.2i. So it's not just a title supervisor, there's specific things that they have to do, right? Work must be done under the general supervision of a person who is authorized to enforce the employer's health and safety measures, right? Training, instruction, supervision, and information. So we need to provide the employees on the necessary information so that they can understand the risks in the workplace. It's not one or the other, it's all four of them. That's why I've created one acronym: training, instruction, supervision, and information. And now if we have the measures, now we've decided, right, we're going to have this work procedure. It's not good enough to have it on paper. We have to actually implement those measures. And then we have to ensure that our employees comply with the OSH Act. To make sure that our employees comply with the OSH Act, we're going to have to make sure that our employees are made aware of the OSH Act. And it's not just good enough to have the rules, you have to enforce your measures necessary in the interest of health and safety. And as I said, work must be done under the supervision of a person who is authorized to enforce the employer's health and safety measures. And then lastly, you have to make sure that your employees understand the scope of their authority. Now, scope of authority is not your job description, right? Scope of authority is what are they allowed to do in the interest of health and safety, and what are they not allowed to do. So, for instance, procedures, safe work procedures. And that's the employer's duty of care in terms of Section 8. So that's what the employer must do. Now, I said to you, all of this must be done as far as is reasonably practicable. Now, what does reasonably practicable mean? It means it's practicable having regard to the severity and the scope of the hazard that we're dealing with. What do we know about the hazard, as well as what do we know about the controls, the availability and suitability of the controls, and lastly, the cost in relation to the benefit derived from it. Now, most people see cost in relation to benefit, and immediately they think if we did not budget for it, or if we don't have money, we don't have to do it. If you think that way, you would be incorrect. You would be wrong. What that means is, if you cannot afford to do it safely, you shouldn't be doing it. This is critical. It's not going to be an excuse to say we didn't have budget. Think about COVID. If you think about COVID, in the beginning when we suddenly had to get masks and thermometers, right? And sanitizer, and there was a shortage of all of this, and it was really expensive. The prices were inflated. What could we say? Oh, we didn't budget for it, and therefore, because who budgeted for it, right? Could we say the prices are too high, we can't afford to pay it, so we're not going to implement it? No, it's not an excuse. If you cannot afford to do it safely, we should not be doing it. You don't have to get the most expensive. That's also not what is said. But you have to understand that you have not having budgeted for safety and for health is not an excuse in terms of this legislation. Right. Reasonably practicable. So basically, if I take reasonably practicable and I try and simplify it, then I'm going to say to you, right, for me, reasonably practicable means you took reasonable steps. Now, what are reasonable steps in health and safety? Step number 1, hazard identification risk assessment. You need to do a proper risk assessment, not window dressing risk assessment, not copy and paste risk assessment, specific to your workplace, specific to your risks, right? Once we understand our risks, what do we need to do? We need to eliminate and control. So we need to be able to see we're eliminating and controlling those identified risks. And then the last thing, we have to be able to show, you saw in Section 8, it says, ensure that your employees comply with the OSH Act. So that's step number 3. We have to comply with the law. And if we take these reasonable steps, then we will not be negligent. But if we don't take the reasonable steps, then we can be negligent. Now, is that really so bad? Yes, it is. So if you take reasonable steps, right, and you do the reasonable steps right, then you cannot be negligent. And if you're not negligent, then you cannot be liable. Remember what I said earlier on? This is criminal liability. But on the flip side, you've got your reasonable steps. If you do this and you don't do it properly, then you can be negligent. And if you're negligent, then you can be liable. Without negligence, there's no criminal liability. Okay. So if I look at this, I always say, this is how I understand Section 8. There's a law, and the law says we have to identify and manage our risk. And to identify and manage our risks, we've got a toolbox. And this toolbox has all of our risk management tools in there. So what kind of risk management tools are we looking at? A few examples. Procedures would be risk management tools. Training would be risk management tools. Inspections, when we inspect the equipment before we use it. When we appoint a supervisor to supervise compliance with the health and safety rules, when we issue personal protective equipment, when we do medical surveillance or hygiene surveys, when we issue permits to work. If somebody's coming to work in my section, before I allow them to work there, we do a risk assessment and we issue a permit to work for the type of work that they want to do. So we're basically handing over to them. That would be a risk management tool. And then also planned task observations. We call them PTOs or PJOs, planned job observations. When we evaluate the employee while doing the work to see that they are complying with the procedures. Now, if I use the right tool for the job or tools, it can be more than one, then I'll be complying with the law and I will also be managing my risk. I will also not be negligent because I will be taking reasonable steps. If you remember the 3 steps in reasonable steps, step number 1, hazard identification, risk assessment. Step number 2, eliminate and control. Step number 3, compliance with the law. Right, so it's a very basic approach, I know, but I think if you use this as the baseline for your health and safety management system, this can help as a starting point. Now, I've talked about the duties of the employer, but what about the employee? So Section 14 of the Act gives us the duties of the employee because the employer has to take the first steps. But once the employer has put his controls in place, then the ball goes to, or the responsibility, let's not call it a ball game, then the responsibility goes to the employee. So who's an employee? The definition of employee says it's any person who is employed by or works for an employer and who receives or is entitled to receive remuneration. That's all of your employees that you've appointed and you pay them a monthly salary, right? Or it's any person who works under the direction or supervision of an employer or any other person. And that's where your labor broker staff comes in. They work under your control or supervision. So what are the duties of an employee? Every employee has to take reasonable care of his own health and safety, as well as the health and safety of others who may be affected by his activities. I always recommend to employers, make sure that somewhere in your workplace you put up something. Doesn't have to be fancy, or do a toolbox talk or a discussion. Casual workers would be labor broker staff, wouldn't they? Do you enter into contracts with casual workers, Gerard?
No, not necessarily, but I think it's like just a temporary, solution to like high volumes or a busy time of the year. So I'm just posing the question,
Yeah.
Would that fall under the employer or labor broker, just to clarify that?
That's a good one, Gerard. Casual labor would be for the time that they are doing the work with you, for you, not with you, for you. They will be deemed to be your employee. That means that these rules will apply to them. They'll have the Section 14 duties, but you'll have the employer duty towards them. Yes, Francois, they are an employee. They are deemed to be an employee, so this will apply to them as well. Good point. Thanks, Gerard. Now, as an employee, my employer needs to put the rules in place, but I need to cooperate with any person to ensure that the duties that they have in terms of the act are properly complied with. So if there's a supervisor who has duties, I need to cooperate with that supervisor. Then I need to carry out any lawful instruction given to me in the interest of health and safety. That means as an employee, there is a procedure. I need to comply with that procedure because that's an instruction by my employer in the interest of health and safety. If there is a situation that I cannot properly deal with myself, then I need to bring this to the attention of my employer or my supervisor. And then lastly, if I'm involved in an incident at work, I need to report this internally. I need to report it to my employer before the end of the shift. If I can't report it before the end of the shift, I need to report it as soon as reasonably practicable thereafter. So if I don't report it before the end of the shift and I only report it tomorrow, my employer can first investigate and see, can they find corroborating evidence that this actually did happen in the workplace? And if so, yes, they'll accept it as a work-related injury. Because remember, if it's a work-related injury, it needs to be reported to the Department of Employment and Labour. You need to do an investigation. You need to submit forms to your Health and Safety Committee. All of those things need to happen for your workplace injuries. Now, if it's a workplace injury, remember then also the COID Act might apply. So it's important to determine, is it at work and in connection with work? That's why we also do an investigation. Right, so those are going to be the duties of the employee. Now, the employer also has a duty of care towards other persons, not his employees. So the employer must conduct his undertaking, his work, in such a way to ensure that persons who are not his employees, who may be directly affected by his activities, are not exposed to hazards and risks. So this is our duty of care towards others. Section 8, our duty of care towards our employees. Section 9, our duty of care towards others. Now, others would include contractors, but only if we've got a contractor agreement with them. The Act used the words mandatories. And if you go look at the definition of a mandatory, it includes an agent, a contractor or a subcontractor for work, but without derogating from their status in their own right as an employer or a user. So in other words, I also have responsibility to manage my contractors if I've entered into a Section 37(2) agreement. If I have not entered into a Section 37(2) agreement, then that means that they'll be deemed to be my employees. Casuals, depending on my agreement with them, will either be under Section 9 or they will be under my duty of care that I have for my employees. Service providers, right? They will be under Section 9. Visitors, the community, even intruders. I even have a duty of care towards intruders. Now, we have to be realistic about this. Our duty of care will be limited to the risk that they pose. The risk that an intruder poses is unauthorized access. So the control that I have to put in place is access control. The control for unauthorized access is access control. All right. I think we're getting close to 11:30, and that's when we're taking a break. I think we've got on the program a 15-minute break. Am I correct, Annelies? Gerard?
Yes, indeed. Is that sufficient for everybody? For you in particular, listener, your voice must be very dry by now.
Oh no, no,
Are you
Annelies. I'm like a train. I can go on for days.
fine?
All right. I think if we can make it 15 minutes, that would be good. Just a comfort break, and then we can get right back into it.
100%.
Right, so
see everybody back at 1:45.